Leader of the Opposition.
Thank you, Mr President. I lead for the Opposition in debate on the Firearms and Weapons Prohibition Legislation Amendment Bill and the Cognate Security Industry Amendment Regulation of Training Organisations Bill 2015. The Opposition does not oppose either of these bills. The Firearms and Weapons Prohibition Legislation Amendment Bill 2015 is particularly important because it gives effect to recommendations related to the review of the Martin Place siege. As the opposition spokesperson in the other place noted, rather than consult with the opposition about the bill or give us sufficient time to deal with its contents before it was debated in the other house, it was dropped on us at short notice, which is most regrettable when dealing with matters of great significance. In his second reading speech in the other place, and I apprehend in the incorporated second reading speech given by the Honourable Parliamentary Secretary in this place, it was indicated that the bill deals with recommendations of the joint Commonwealth and New South Wales review of the Martin Place siege, which reported in January 2015. The report of the review said, and I quote, "The Commonwealth and the States and Territories should give further consideration to measures to deal with illegal firearms," unquote. The report found that man Haron Monis had a pump-action shotgun in his possession. He did not have a firearms licence, and the gun may have been a, quote, grey market firearm, unquote. Most gun owners in this state do the right thing. This bill is not aimed at them, but at those who would engage in criminal activity. As the Minister outlined, certain firearms present a greater risk to public safety than others, as they are more likely to be used for a criminal purpose. This bill is intended to deal with those firearms. This bill seeks to rectify the fact that there is currently no offence for the possession of a stolen firearm, as indicated by the Minister in his second reading speech, and this bill seeks to remedy that by introducing a new offence. The bill increases the maximum penalty for a number of offences, which is said is aimed at reflecting the serious risk posed by some firearms. The bill provides for a consistent maximum penalty of 14 years imprisonment for the possession, use, supply or acquisition of a firearm where the firearm is a prohibited firearm, has had its identification marks, numbers or letters defaced or altered, is unregistered, is stolen or is not authorised by licence or permit to be in the possession of that person. Section 51 capital F provides that a person must not possess or control a digital blueprint for the manufacture of a firearm on a 3D printer or electronic milling machine. The maximum penalty for this offence is 14 years imprisonment. Importantly, the bill recognises advances in the online environment and in Technology Act captures blueprints held in a cloud environment or by a server outside New South Wales or indeed Australia. This new offence is appropriate at this time. It recognises the important role we play in the Houses of Parliament in reacting to issues as they arise and to change, particularly changing technology. Now, while the opposition will not oppose the bill, we have some concerns about the amendments to sections 10 and 30 of the Firearms Act, which allow for the Commissioner of Police to consider the spent convictions of applicants for firearms licences and permits. These amendments allow for Section 12 of the Criminal Records Act not to apply in relation to an application for a firearms licence or permit. Spent convictions apply to those convictions where a bond was given or a sentence of less than 6 months was imposed. For a conviction to be spent, an adult must be crime-free and must not have been imprisoned for the past 10 years, and for a child the applicable period is 3 years. Whether those spent offences impact on a person's application for a firearms licence or permit is left to the discretion of the Commissioner of Police. It is hoped that discretion is used wisely, given these people have done their time and their sentence was less than 6 months. As I have said, we have concerns about this aspect of the bill, but it will not lead us to oppose the bill overall. I turn now to the Security Industry Amendment Regulation of Training Organisations Bill 2015. This is important legislation which ensures the New South Wales Police Force has the requisite authority to regulate and audit private training providers who offer security training qualifications in our state. The importance of the quality of well-trained security officers cannot be overstated. They are often the first line of defence at community, entertainment and sporting events across New South Wales. It is therefore imperative they have the knowledge and skills to deal with complex security issues in a professional and secure manner. Unfortunately, the security industry in this state has not always been characterised by these high expectations of service delivery. The Independent Commission Against Corruption Operation Columba inquiry in 2009 shone a light on the provision of security training in New South Wales. The corrupt conduct that was uncovered as part of that inquiry was a wake-up call as to just how important the issue is and why we must all work together to ensure security officers have completed all the necessary training and gained the appropriate skills as well as the piece of paper said to be the qualification, and that the training and qualifications are of a sufficiently high standard as expected by the wider community. One of the key recommendations for that review is for greater oversight and quality control by the New South Wales Police Force. While the New South Wales Police Force has taken important steps towards the practical implementation of this recommendation, it is important that after 6 years this recommendation is enshrined in legislation so there is no conflict with Commonwealth laws. The bill amends the Security Industry Act 1997 to ensure that the New South Wales Police Force has total certainty with regard to its role and responsibilities as the key regulator of the New South Wales security industry. The opposition is pleased the Minister has confirmed that the Commonwealth supports the continued involvement of the New South Wales Police Force in regulating the security industry. The opposition does not oppose the bills, but we are disappointed that once again on an important bill, or two bills, particularly one that deals with the recommendations of the New South Wales Martin Place Siege Review report, that the opposition was not given sufficient time in the other place to deal with the legislation before it was rushed through. We note, for example, the significant difference in the way in which the Parliament was able to handle the government's ICAC package with bipartisan support and the recent bumpy landing of the Courts and Justice Portfolio Amendment Bill, which also impacted on the operation of the ICAC. Bipartisanship in important areas, particularly to do with public security and public safety, as well as important matters of corruption, should always be conducted on a bipartisan basis. Mr. Assistant President.